at all. Just from
Lordship,
yesterday, or
while pressing your
2-3 days prior, we are just keeping. We are going, in fact. I have a flight. I don't know, sir. Sorry, very sorry.
Deeply.
Where is the lordship? My lord, I beg to mention item number 25, my lord.
25.
25.
Hmm.
Very heading, my lord.
Starship submarine.
25. Are you on interim otherwise?
No, man.
You are not in interim. Okay, then appear before the tripod below with an appropriate application for pay. Yes, what is the CS number?
CS number 48/25 dated 30/3/25.
48/25 dated 30.
30/3/25.
Highly obliged.
Release item 1.
May I please the lordship? Lordship, the matter may pass over timing.
Now, see, time being, I cannot say today because actually we are in.
After being.
So if time being, then it will be after Bihu, I think. I don't know. Anyway, how many days he is in custody, in fact? Since how many days? Do you have any idea? Who is the engaged counsel?
A Medi.
A made him. It will come after Bihu then. What is the position? Do you know?
The position is of
Plastic pouches containing brownish powdery skeleton.
Since
He
when
was
he is in
arrested on
custody?
10/3/24.
10/3/24.
Oh, lordship. It's a charge sheeted matter.
Okay, then after Bihu.
Lordship,
Okay. And the request for it after Bihu. Do you want any date fix here? Date, if you want date, then it will.
any fixed date that after.
Then it will be obviously on the later part or the first part. Yes, when can be. 30.
Much of it. Much of it.
Item 2.
May I please the lordship?
Yes.
I am absolutely sorry to say that my lord, my senior is coming, my lord, due to traffic jam, my lord. Only 5 minute time will be given, my lord.
Okay, timing I will keep it.
Only 5 minute time, my lord.
That's what timing I'm giving.
Yes, thank
Okay.
you. God bless you. Bless you, my lord.
Item 3.
May I please, Lordship? Lordship, bail application, my lord, under DNSS. NDPS letter, my lord, charge sheet.
NDPS charge it.
NDPS. Commercial quantity, my lord.
Since where your petitioner is in custody?
Custody, my lord, as on today, 1 year, 11 months, 2 days, my lord. As on today, my lord,
1 year, 11 months,
2 days.
2 days.
That's charge sheet, my lord, file on 28/9/2023, my lord. As charge sheet number 128,
CS 28,
dated 28/9/2023.
23.
My lord, prosecution relied on 8 witnesses. Till date, my lord, only 3 witnesses are examined, my lord.
Otherwise relied on 8 witnesses.
8 witnesses.
Until now, 3
Till now, my lord, 3 witnesses
examined.
examined. One more, my lord, one of the court accused, my lord, already granted bail by this honorable court.
Co-accused.
Co-accused, my lord.
Have you annexed the order of the?
My lord, yes, my lord. I will next day order. Page 42, my lord. An extra
Page
5.
42.
An extra 5.
So in regards to recovery, you want to say anything?
Sorry, my lord, cough syrup, my lord.
Pardon?
Cough syrup has been.
No. Regarding recovery, do you agree that it was recovered from you?
Recovered, my lord, it's a truck, my lord, and I'm the truck driver and helper, my lord, 2 petitioners,
Or you are the truck driver?
my lord. And one more ground, my lord, regarding notice and arrest memo, my lord. And there is nothing about the ground of arrest, my lord. But I've not annexed those documents.
Records may be called for.
Records may be called for, my lord.
In that case, to record to me, I thought that you have already
No,
annexed.
my lord.
If you have not annexed, then we don't have it already. We have to call for the scanned copy of the case record along with the case diary. or in the meantime, what I'm suggesting you, we are calling for the case diary, sorry, case record and case diary. If suppose if any reason it doesn't come, suppose, then you can obtain for the certified copy and it can be placed before us,
Fine.
okay? Otherwise, without any, we are not in a position. Or exclusively considering your incarceration is also difficult at this moment, because within 1 year, 11 months, 3 witnesses are already been examined. So it may not be a case for long incarceration also. That's right. Yes. Pardon?
Records.
Yes, yes, we are calling for the record.
Date should be then after the.
After the unit is.
And obviously after we,
May month, first week of May also.
5.
2-5,
Yes.
Item 4.
yes.
Lordship, 30 days when the bar lordship individually category lordship. And main case is that lordship another co-accused bail is fixed lordship 123 lordship. And everything is record from him lordship, not from me as lordship. Lordship may be taken up a fixed on the day lordship on 23rd.
Case diary and along with FSL report. Well, intermediate.
Otherwise, it is a charge sheeted case.
No, no, lordship.
Investigation.
Not yet charge sheeted.
Yes,
Since when he is in custody?
38 days lordship.
Today, 38 days.
Yes, as per
So we
my-
need at least something for us. Or any other ground you have taken? No. That is the main ground. Recovery was not from you.
The dhaba lordship and where the driver lordship, we were there for dinner lordship.
Okay.
Intimately, there's after done lordship.
From Dhaba, it was recovered.
Yes, lordship. And that honor is the main accused lordship. His bail is lordship fixed on 23rd lordship.
23rd.
Third lordship.
List on 23rd. We call for the case diary. CDB call for list on 23rd. Okay, we are listing on the same day.
Item 5.
Official lordship.
Yes.
Lordship is a 483 BNSS application lordship. The accusers petitioner was arrested on 25/9/24. It's been 199 days from the date of arrest.
29.
199 days.
No, when it got arrested, he got arrested on
25/9/24 year
25/9/20.
lordship. 199 days till today lordship from the date of arrest lordship.
POCSO 6 is there.
Otherwise, case is charge sheeted, I think.
Such
Search it and the statements of the informant and the victim has already been completed.
Oh, achha, very nice. But we have to comply with the formalities, so we are issuing notice at this stage. Otherwise, we don't have any alternative because it is 6 POCSO.
Lordship.
Should notice you take step within, obviously today is the last day. If you can take step today, it's okay. Otherwise, see, tomorrow is second Saturday. So within 1 week, at least try to take steps.
Or just after Bihu lordship.
Yes, obviously after Bihu, the CT case record along with the CDB call for. With the present status report. Registry will do the needful. Step to lower the through register process, so and so. 2-5 will do. 2-5 will do, 2-5 or 1-5? 2-5.
Okay, sir.
Item 6.
Lordship, I'm appearing on behalf of my senior SK Nages.
Hmm.
Lordship, I can call for the CD.
Here you need the CD. Is it charge sheeted one or not? Charge sheeted. CD in a says case record will be called for. Case record along with the case diary be called for. Same day 2-5 will do, 2-5. Okay, 2-5. In the meantime, if you want to file any objection, you can. Okay. Apart from respondent is at liberty to file written objection if any. Okay.
much option. Thank you.
7.
My lord.
Yes.
FIR is place 13, Barnacular, my lord. And the petitioner was arrested on
FIR is at page 13.
13 months.
Hmm.
On 12/3, you are arrested. Is-
12-3.
12-3, ma'am.
Hmm.
Is also can you say? Okay.
Yes.
That I was arrested without having any notice.
Hmm.
And also even after arrest, no notice has been served to the family members or others. That about my lord, the last vacancy forwarding report, they have taken me 5 days custody, police custody. They interrogated me.
Guru, it's related to cow or what?
Cow, they say some cow, beef has been sold in the some Doramere Sod area. The police suspected me, my lord. No cow was sold, my lord. Some persons sold the beef in the market. The police say that I am the person.
Open market you're selling.
Open market, village, market, not market, Chor area. Doramere Sod, Gao village. Some persons, other persons, my lord. They say I am the persons, I stealing the cow and I do that business. my lord. Actually, nothing has been, my lord, also is according to page 15,
Page 15.
page 15. And thereafter, my lord, I was taken police custody on that day. And page 17 is the second forwarding report, my lord. After completing the police custody, again police me go to court and now I am in jail. Uh, 12-3 already,
Yes.
and no notice also served. And today, my lord, notice was also served to the family members or others, my lord. After arrest
Have
also.
you annexed this one? This
No,
thing?
no, not sir. Not sir.
But 47 is there?
47 is also not there. 48 is not there.
But he is not annexing this.
No, I make a statement, my lord. Page paragraph 4, my lord.
No, we are dealing with the cases of this non-compliance of
Yes, yes.
this
Paragraph
47,
6, my lord.
48.
Paragraph 6.
But for it is your from verbal submission only. How can we pass the order? That is, if this
No, no,
CD comes, then only we can peruse that whether this is available or not. Or you could have applied for.
But I, paragraph 6 is also can be seen.
No, this is mentioned by you only,
Yes,
but
yes.
we don't have anything to
Oh,
see.
my lord. No,
Other
apart
requests.
from that, my lord, I am not, apart from that also, but 12-3, I mean.
You are in custody.
Yeah, by considering that, my lord, may be considered, my lord. 12-3, but cow, some persons sold the cow beef in the market. I was,
They stolen the cow, cattle, and illegally slaughtering them and smuggling.
then, my lord,
allegation
my
is
lord, theft is there, my lord, so 12-3, I arrested, my lord. Consider that aspect, my lord. By consider that aspect also, length of
Yes,
detention.
Goswami. Or Mr. Hussein. No?
Jahan. My name
Yeah,
is
oh, it's not name is not here.
no wrongly.
You are appearing for
petition.
petition.
Now, my name is also there in the Kolatnama.
Acha,
But
acha.
as a wrongly.
J. Ahmed, counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application, section so and so in connection with so and so. It is submitted by Mr. Ahmed that as an accused petitioner is in custody since last 12/3/2025, and thus they have got sufficient opportunity to interrogate him, keeping him in custody. And accordingly, he prayed for release of the accused petitioner, considering his length of detention. He further submitted that the notice under section 47 and 48 was also not provided or served to the present petitioner. Which is mandatory required under section 47 only 48. Oh, no, which is mandatory required. And thus violated the provision of the article 21/22(1) of the Constitution. Next, in this context, Mr. Goswami, the learned additional PP, submitted that from the grounds of arrest, it is seen that he is involved in committing theft of the cattle and illegally used to sold the beef meat by illegally slaughtering, they used to sell the beef meat. However, considering the length of detention, it may be considered. only considering length of detention query, under which it is pending,
My lord.
in
Oh,
which jurisdiction?
In the Chief Judicial Magistrate Kokrajhar.
Kokrajhar, CGM Kokrajhar. Okay,
My lord.
Sorry to interrupt, Lordship. Lordship already passed order in item number 6, Lordship.
Hmm.
Lordship called for LCR, Lordship.
Hmm.
Lordship, she is a lady, Lordship. LCR will be received from additional session judge number 5, Lordship. She has some personal difficulties, Lordship. Some problem is going on here at her home, Lordship. Husband expired. So, Lordship, can it be picked the last of April, Lordship, if possible, instead of 2nd of May?
29, 30 your by 29.
Lordship. Obliged. Item number 6.
Is a charge sheeted case?
Succeeded LCR will be from.
এটা আপনি কি কল করেছেন? Your someone has come and
Yes.
asked for the CD
I
only.
Rich Lordship that.
Acha, no, he was praying for CD only. That is
No,
not
no,
the
it's LCR.
LCR, no?
LCR.
No, he is saying that CD no, he is. Can
LCR
copy
and
the
for
LCR?
objection of the other side.
Yes, yes. Scan copy of the LCR along with the case file. Okay, 29.
Obliged.
Item 8.
Okay, item number 8 and 17, Lordship, arising out of same FIR.
8 and 17.
70. Wherein item number 8, Lordship will
17
find.
is in bear, in motion column. No. No, 17 is also in motion column.
Motion,
Yes,
both
yes.
are motion matters.
Yes, yes, I'm.
And in both cases, Lordship, that grounds were not informed, that is the plea, Lordship. And in item number 8, page 45, 46, and 47, your Lordship will find the arrest memo, notice under section 47, and the inspection memos are there. I am having the certified copies also. And enclose the Xerox copy of the certified copy at page 45. No grounds were mentioned.
45 is the 47 notice.
And
48 is the
46
arrest
is,
memo.
arrest memo. And 47 is the inspection memo.
Negative ground. Page number 45, 46, 47. Okay, annex kora ase. You can look after his. 47 BNSS. Arrest memo under section 36 BNSS. And inspection memo, no grounds of arrest. It will mean. Otherwise, what is your other submission?
Other on merit, Lordship, at this stage, I am not submitting.
Since when he is in custody?
Since Lordship, 18/8/2024.
18/8/2020.
Yes, Lord.
Case has already been charge sheeted.
Yes, charge sheet. I have enclosed the charge sheet, page 21.
Case charge sheeted 18/8/2024. He is in custody. Case has already been charge sheeted. No witness, I think it is.
Not examined.
No witnesses is examined till date. Yes, Gusami.
Yes, the charge sheet is something very recently, 4/2/25. For
Otherwise, it's about commercial content.
commercial content.
Okay.
In
Yeah,
item
under whose satisfaction this one?
special judge Sri Bhumi, Lordship.
Special just Bhumi.
Yes.
This is of 8 and 17.
17, Lordship will find that he earlier approached before the honorable court, but charge sheet was submitted, that page 46. And subsequently he filed bail application and renewed the prayer after rejection, Lordship. And here also page
Where is the rejection order?
that your Lordship will have page 46, not rejected, Lordship, because charge sheet was submitted. So it was given, liberty was given to him to approach the trial court, Lordship. Accordingly, he approached, and now he, as his application was rejected, page 48 by the trial court, and therefore he is again renewing his prayer, Lordship.
48, it was rejected.
Yes, by the trial court. After that, charge sheet was submitted, because this honorable court given the liberty to approach the trial court, because charge sheet was submitted. And accordingly, he filed bail application before the trial court, that was rejected again. So now again, he has renewed his prayer, that page 50, your Lordship will find that notice under section 47. And page 51 is the arrest memo, and 52 is the inspection memo. No grounds are mentioned. So similar to item number 8.
Further submit, Mr. Ahmed further submitted that earlier the present accused petitioner filing bail application before this court, but as the charge sheet was already laid while during dependency of the said application, comma, this court directed him to appear before the learned trial court below with an appropriate application for bail. And accordingly, may the present accused petitioner also approach the trial court below with an application for bail, but his prayer for bail was rejected. White order dated 24/3/2025, passed in special and NDPS case number 90/2024. এইখিনি এটা issue, and then subsequently, and same date of arrest
The
is
date
also
of
same
arrest
here.
is different, Lordship. Nothing was recovered from his person. Date of arrest is 22/9/2024.
22/9,
Yes, Lordship.
22/9/2024.
20.
Nothing recovered. Yes, Goswami, under the same footing it will go. Sri Bhumi.
Item 9,
May I plead, Lordship? It's 483 application, Lordship. And it's 380/427. Lordship, I am in custody since 23/24. Lordship. The FI page number 11. Type copy.
FIZ page number
Page number
11.
11. Type copy.
Hmm.
This FI was filed in 15/6/24. Lordship. And after I gave up almost 8 months, I have been arrested. In the FI, Lordship, the informant says that some person has stolen his golden ornaments and rupees 1,73,000 from his house. Some CCTV footage can be seen. They also stole away the CCTV machine, and he also specifically stated a person who has called over telephone number is given, and same person is also call telephone or seeking rented house in his house. And then subsequently, I have been arrested on 23/25. I have a jewelry shop, Lordship, in the Hathigaon area, and some golden ornaments were seized from my shop. After I gave 8 months, Lordship. Page number 21. Type copy, Lordship, is the seizure list.
You got arrested in 20/03/2025.
Your Lordship.
You wrongly mentioned as 24 in your cost tag.
Lordship.
Anyway, then further. So your petitioner is has a gold shop.
The Hathigaon area and also in Hojai. I have annexed the trade license of Hojai, as well as this the delegate card which I appeared in Guwahati, Your Lordship, to exhibit this my ornaments, and some ornaments were seized from my shop and the case amount from my house, and then I have been entangled in this case, Your Lordship, for no fault of me, and I am behind the bar for 22 days, Your Lordship.
So these things are going on, in fact.
Lordship.
Your petitioner may be innocent. I'm not on that. But the question is that some gold shopkeeper used to buy those stolen articles, and these are the habitual. That is the reason.
Even some lesser price.
Hmm?
Even some lesser price, Lordship.
Yes, in some lesser case.
Okay, then we cannot take this case.
We'll have to call for the case diary. PDB call for. কি কৰিব আৰু কেতিয়া দিম? End of April. End of how many you are in custody since?
22 days. I am since
23,
23/25.
22 days.
22.
28, 29 and come out দিব পাৰি নেকি এতিয়া? 29.
All right.
item 10,
May it please your Lordship, my lord, matter relates to, my lord, arrest under section 69 of CGST Act, your Lordship.
Who is appearing here? Just a second. Mr. Kyle is there?
My lord, his junior is there. In fact, this matter is.
No. He is appearing.
He was here.
Yes.
So, my lord, I am in custody since 23/1/2025.
23/1.
2025. And today, my lord, 78 days, your Lordship. So my prayer before your lordship is on, my lord, notice under section 41A, which is required. And as per Ernest Kumar decision, and which in Satyendra Anjil it has been held. If it is not given, then I am entitled to bail your lordship. My lord, reason to believe, which is the mandatory precondition, that copy has not been provided to us at the time of my lord arrest, your lordship. My lord, as your lordship is aware, my lord, under section 132, if it is less than a maximum 5 crore, then it is bailable, your lordship. And if it is
In your case, what is the
my lord,
amount?
it is it is non-bailable, your lord. 6.24 crore approximately, my lord. That exact figure I am giving your lordship. And without, my lord, ascertaining, my lord, whether this is 6 crore, 7 crore, because we are disputing it, my lord. So, my lord, in my humble submission, this honorable court that your lordship will find at page 71 in similar situated condition. Only case number and name is required to be changed, my lord. Otherwise, my lord, it is tailored made. Paragraph 23, page 82. After considering the decision of Honorable Apex Court in Radhika Agrawal also, held that, my lord, 41 and 40, may I read your lordship? It is seen that there is no dispute in regard to the arrest memo issued by the respondent authorities by complying all necessary formalities under section so and so. But it is the issue raised by the petitioner that there was no proper compliance of section 41, 49 CRPC, which are mandatorily required to be followed. From the view expressed by Honorable Apex Court in Radhika Agrawal Supra, it is evident that though the GSTJ is special enactment, but the same cannot be considered as complete code in itself as regard to the provision of search, seizure, and arrest. And as stated above, the provision of Code of Criminal Procedure would be applicable unless it is expressly or impliedly barred by the provisions of the said act. But here in the instant case, it is seen that there is no compliance of section so and so, which is mandatorily required to be followed as per the guideline of Honorable Supreme Court in the cases of Ernest Kumar versus State of Bihar and reiterated in Satyendra Antil versus CBI. In Satyendra Antil, it says, my lord, if it has not been done, then bail should be granted, your lordship. That I will, if your lordship required, I will place, my lord. More so, there was no compliance of so and so at the time of arrest made by respondent authority, which is in violation of Article 21 and 22 of the Constitution of India. The ratio laid down by Honorable Apex Court in so and so, my lord. It is also an admitted position that in the authorization letter, as well as grounds of arrest, which we have communicated to the accused petitioner, the DI numbers are missing. In present case also, your lordship. Though in the arrest memo, the DI number was incorporated in the handwritten form, which was allegedly inserted subsequently. But as per circular so and so, the arrest memo and other documents which are to be supplied to the accused, the DI number has to be incorporated. Otherwise, it shall be deemed to have never been issued. Coming to the communication of reason to believe, it is seen that admittedly the reason to believe was duly recorded in the file at the time of issuing authorization of arrest. It is also an admitted fact that it is an internal and confidential document when the arresting authority will record their reason to believe before issuing any authorization letter. But as per the view expressed by Honorable Apex Court in Radhika Agrawal, it can be held that reason to believe are to be furnished to the arrestee so that they can challenge their legality of arrest. But here in the instant case, though the reason to believe is found to be duly recorded by the authority concerned, but the same was not communicated to the present accused petitioner at the time of arrest or while furnishing the grounds of arrest. Thus, it is since that no compliance of so and so was not communicated, which are mandatorily required to be furnished. And the same time, the reason to believe as recorded by authority was also not communicated to the present accused, which may be the ground of consideration for wealth. It is also seen that when thereafter,
The question is that,
Please, your lordship,
yes.
the earlier bill application was rejected by Honorable Mrs. Justice Malasin Nandu. So this matter pertains to
Oh,
the
acha,
appropriate.
then
no,
to-
but as per notification.
yes, for notification, we just confirm.
My lord, I am giving
No,
That-
notification is
that
just
is
confirmed by the
taking
office.
criminal
Please.
matters,
It
lordship.
has been already confirmed by the office.
Lordship.
Once rejected by, but now second subsequent notification, those which we are going to implement. The
Please.
question is that subsequent notification is that if the bench is, suppose in the outlining
Yes,
bench,
right, this is
outline bench,
division bench.
suppose, outline bench, she is taking, he or she is taking, suppose the
If there is no
civil
roster.
matters. But the exclusively the rejected one has to be there. That
My
is,
lord, but as per notification.
no,
they have
whatever
allowed-
notification, we are sorry.
That bench
Then
is
on the
taking
last,
criminal
last
matter.
occasion also similar matter was there, and then again we
And
reformulated
that
the
bench
order and
is
send it
taking
back to the
criminal
appropriate
matters also,
bench.
Lordship.
My lord,
Yes,
if
sorry.
your lordship may not,
Very
take,
sorry.
but not
No, no, I
notification-
know the notification. What notification
It
says?
says, my lord, roster, my lord, there is no roster. See, my lord, Justice Nandi is sitting in division bench.
Whatever,
And
you
criminal-
have to be there in the, well, in the case of rejected order, otherwise it can be.
Okay.
Suppose has called for the CD, it was pending earlier, or it's been disposed of or allowed, that, or
I
this
don't
kind
think,
of
my
things,
lord,
it was
subject to, my lord-
rejected, yeah, please sign, no, in
And
one of his.
Lordship, today
Exclusively,
This is
no,
a-
notice I have, no, notice I
But
have.
here it is written, let me
Exclusively.
conclude. Here it is written-
Exclusively on the rejected
My lord,
count.
because of that, my
Sorry.
lord, the petitioner will languish in jail for.
No,
another
no,
10 days.
sorry, we are not in a position to touch your petition. You have to.
But
approach.
what is to be
criminal
done?
matters are
Registry
listed
has
for 10
listed
days.
here, and 10 days. there
That is how registry is registered. Kyo bare to come Korea.
My lord, my lord,
Ask the registry people come.
my lord, I
Ask
am
them to
suffering.
come.
your lord.
Ask them to come. We are come calling it. I mean, I put you. That should not be done by the registry also. That is the
My lord,
specific
if
order
that
of
is
the
so- we have annexed that
Honorable
order also.
Chief Justice only. Said it cannot be, I mean, placed before the another bench if it is rejected. Not the case of
May I-
pending and all.
May
If it is rejected.
may I pray, my lord, I have one only option before Honorable Chief Justice. I will go and mention before Honorable Chief Justice. Till then, your lordship may not pass any order.
No,
What,
I'm not passing. I'm just calling the registry people also.
my lord?
Okay.
I'm mentioning before.
Because that is their fault also. Why they are placing
My
it
lord,
before us?
I am ultimately, I am suffering, your lordship.
Obviously, that
No.
is that I can understand. Because similar order
It
has
may-
already been
my
passed by
lord.
this court. So that should not be placed before this court, and the registry should
And it was,
actually know the all
it
these
was
things.
mentioned, my lord, before registry also, it should be listed. Last day is there, my lord. Now, in the last day, they have listed, if
That is
so.
their fault, but we are not in a
So
position.
what I am praying, my lord, your lordship may call registry also. In the meantime, I am going to mention before Honorable Chief Justice.
What you can do?
My lord. Deep law.
And Lordship, one more submission, that bench is taking criminal matters today.
Criminal matters today also.
So
But
Lordship,
there is no roster, my lord.
Criminal, she is taking
our
criminal
matters are listed
matters.
before that bench.
Why
If
registry
the
has
bench
done
is
so?
taking criminal matters, then it can be placed.
Well, why registry has done so?
That's what I'm just asking
Lordship.
him, asking. It is
My-
strictly we are not taking the rejected matter, especially the rejected matter. Oh,
Much of
I hear that. Fine.
Item 11.
May I please, your lordship? Lordship, in this present case, lordship, I am taking that ground.
Our registry ফালৰ পৰা কিয় direction বিলাক ভালকে নিদিয়ে? It is not, should not be there, na? Our registry has put up before this code. Why? They should see. যোৱাকালি, in fact, yesterday or day before yesterday, I also talked with the registry. Because one matter was there. In that case, they have said other matters if it's pending, or other matters, suppose if it's allowed earlier, but whatever, that matter can be placed if the bench is not available, suppose. Out of same FIR also we can take. But in case of if it is rejected, that too by the senior bench, that has to be there only. That is the view expressed by the registry only. Then why they are doing similar kind of mistake? It should not, pardon?
Earlier case, Lordship, he has annexed the rejection order. Yes, setting that
No, it's a allow order, not rejected.
allowed.
Otherwise, lordship, notification is very clear, lordship. If it is rejected, then it has to be go there.
That has to be there only.
Why is it?
My lord, in this present case, lordship, I am taking that ground of lordship, non-furnishing of the ground of arrest, lordship. Lordship may kindly come to page number 40, lordship.
40. বাৰে বাৰে এটা কাম কৰি দিব নালাগে নহয়, এইটো ঠিক কথা নহয়। কাৰোবাৰ কাঠত কাৰোবাৰ হেৰিত প্ৰেছাৰ কৰি দিব নেকি? What is this?
Lordship may kindly come
This
to
is
page
the
num-
inspection memo.
kindly come to page number 41.
41 is your inspection
Inspection
memo.
memo.
It's the original one.
Yes, lordship. Lordship may kindly come to page number 42. Notice under section 47.
Hmm.
My lord may kindly come to page number 43.
This is
Arrest
the
memo.
arrest memo.
Yeah.
Your petitioner is otherwise in behind the bar since when?
Lordship, he was arrested on lordship 8/2/2025. He was arrested only on the basis of the statement of the co-accused. Nothing was recovered from the
25
possession of
on
the
the basis
petitioner,
of the
lordship.
court's so and so. And case is not yet charged sheeted, I think.
No,
Commercial quantity.
commercial quantity, lordship. Nothing was recovered from the possession of the petition. One other person was arrested. He said that both the petitioner and that person, they went to purchase. He purchased, the petitioner did not. Even they were not present at the same point of time, lordship. The petitioner was
It
arrested.
is for which satisfaction?
Lordship, special just Sribhumi.
Sribhumi.
Yes,
Special justice. Okay, Kusam, we'll record one part of your submission in our
yes, sir. highly organized.
মানিছে নে ইহঁতক ৰেজিষ্ট্ৰি কি উল্টা পুল্টা কথা কোৱা আহিছে নাই ground up. Yes, that is it, that is it. Now he is rightly pointed out one thing. The copy of order which was my first order regarding 4748
Got it.
and next subsequent order also we have already sent to the Secretary Home and the Department and the Law and Department also. But even after that, if the person is supposed arrested on 8/2 or whatever in the month of February, in that case also how it can be? You just inquire about the matter. I just asked Mr. Das also, the Das that to inquire the matter and to at least do something. Merit wise, some bail is allowed, bail is granted, that is long incarceration. These are the grounds that may be, we are not on that. But the question is whether the procedural lapse is there. Now see, no, we are not on that, but the question is that
Yes, yes, Lordship.
again, similar kind of the mistakes they are doing are now at present
And
also.
DCP has circulated all over, all circulated notice, Lordship.
You
Notices
just
are there.
inquire about the thing.
Lordship,
What is actually happening? Is it the intentional or it is the intention of the police officer to release all the accused persons with some other benefits and all? I don't know. There may be. Repeatedly, how they are doing all these things.
The recent cases, Lordship. all.
There are recent cases. Otherwise, see, other cases, it can be understood. But it is only, your petitioner is only eight to 25
Yes, Lordship, February, Lordship.
February. The-
Even Lordship, yesterday, Lordship, I got 2 arrest memo, Lordship, where Lordship, the ground of arrest, Lordship, is elaborately explained, that too, Lordship, in 2 different languages.
Okay.
Assamese and English, Lordship, everything is there.
Okay, okay. Everything is there.
Everything, Lordship.
Okay, okay, we'll be it.
High level.
Oh, কি হ'ল কওকচোন সেইদিনাখন আহি কোনোবা এজনে কৈ গ'ল যে আপুনি অহা নাছিল কোনোবা এজন আহিছিল আহি ক'ল যে বাকী ৰেজিষ্ট্ৰি আপোনাৰ হেৰি লিষ্টিং হ'ব নালাগে মানে যদি চাপ'জ আৰু সেইখন নটিফিকেশ্যনেও কয় যদি চাপ'জ তেওঁ চিভিল বেঞ্চ লৈ আছে ডিভিজন বেঞ্চ লৈ আছে ইফ ৰোষ্টাৰ ৱাইজ তেওঁ আউটলেণ্ড বেঞ্চত আছে
I have arrested on 12/2/2025.
12 to 25
12/2/2025.
what nature of case this is
Case-
is also NDPS or
And
not?
yes, madam. So purely a suspicion, madam, it is on the face of the record.
Nothing was recovered from
Nothing was recovered.
Nothing was recovered from his person purely on suspicion. He is in custody since 12/2/2025. Or what the grounds of arrest? You're supplying with 47 then?
47.
How many of petitions are there? One is
One is
Laba.
Fasrul Islam, another is Lubadur Rahman.
Lubadur Rahman. But you're supplying arrest memo for only one.
All I have annexed, madam. All I have annexed and others is also there, madam. Others also
No,
there.
no,
madam.
today you are supplying this one only Samadud. This one.
Yes, madam.
Arrest memo.
Yes, madam, arrest memo. And these are also, madam. Lubadur Rahman, Fasrul Islam also, madam. Kindly.
No, you denied it. He's supplying before us the arrest memo of only Samadur. Other one,
Yes, madam, other one.
Lubadur. Kuntu Lubadur.
Lubadur and Fasrul Islam, not Samadur.
Oh, sorry,
Lubadur.
Kustul. That's right.
Lubadur is the brother of Lubadur.
Acha, Samadur is your brother. Lubadur are Kastul. Paki other streams. Is from any other allegations. It is not yet charged sheeted, I think,
Not touched.
not yet charged sheeted.
Commercial quantity.
Commercial cost not yet charged sheeted. Basically, if you want to charge it now, the in committee matters so for another party from the ground of arrest. And from the FIR itself, it is seen that there are sufficient committee matters collected by the IO before the arrest of the present petition. Okay, is whose satisfaction?
Madam, special just Rebun,
Special justice.
pending a session just Rebun. But one unusual submission, madam. On the other day, madam, your lordship expressed to you that I have not mentioned the earlier rejection. That I have categorically mentioned, madam, in my petition. I have checked, obliged.
13,
May it please your lordship, this is a application under section 483 of BNSS, your lordship. The petitioner was arrested on 17/10/2023. About 1 year, 6 months have elapsed. Your
17, 10.
17/10/2023, nearly 1 year, 6 months, your lordship. There was, your lordship, it's a charge-sheeted case, and under section 21C 29 of NDPS, 457 grams of heroin were recovered from a car where 2 persons were arrested from that car where it was recovered. They have led to a lodge. In the lodge, the petitioner along with another person was there, and they were arrested from there. And my, and
You
your
want to say
lordship,
that
nothing was
the recovery was not from your conscious
no,
possession.
not a, no recovery from our possession, nor from the lodge, in the room of the lodge. There's no possession. This is basically the facts of the case. And your lordship, with regard to the point that we would like to mention is that under the, in this case, the arrest notice under section 50 and 47 BNSS have not been followed. And that I have annexed at page 87. And the certified copy of the memorandum of arrest is there. Ekon details. Page 87 is the notice, and the memo of arrest, your lordship, the certified copy is there. I have given. Typically, and in fact, in this case, your lordship, there are 12 listed witnesses, and not a single witnesses have been examined till today. About 1.5 years have elapsed. One more, your lordship, rare here was that this petitioner is actually suffering from cardiological problem, and he has a spinal problem, so he cannot walk. He has to take, I think, some. He used to work with some, we say, I don't know that word, with support. Otherwise, I have annexed the documents. He's been treated in the Guwahati Medical College from the hospital, from the jail itself. I have given all the documents with regard to his cardiological problem and the spinal problem. These are all these documents your lordship will find from page 65 onwards. He has been treated in the Guwahati Medical College during this period. From February, it's from February.
Yes, Mr. Jain.
Lordship, at this stage, LPR may be called for lordship. It may be fixed immediately after view, lordship.
Immediately after being. At best, can it be on 24th? And at best, can it be 24th?
Yes, lordship.
24th.
Much obliged, lordship.
Much.
Please check what you need. Okay.
Much obliged.
14,
My lord, 14 can it be taken up after some time, making this clear on behalf of Sir M. Ahmed. He's in Lexington, court number 15. M. Ahmed.
15,
May it please the lordship. My lord, in this case, the present petitioner is behind the bar for last 1 year, 6 months and 15 days. My lord, the present petitioner also approached this honorable court earlier, my lord, because he was suffering from some medical conditions. Lordship will find this order at page 4. And that court, my lord, on perusing the medical records,
Page?
page 4, my lord. He earlier approached this honorable court on medical grounds, my lord.
Acha.
And the state was directed to provide all the surgery and other post-surgical facilities to the present petitioner, my lord. That order is at page 34, and operative page, the part will lordship it, will get at page 37, my lord. Page 37.
Hmm.
Yes. Now, my lord, he is approaching this honorable court mainly on the ground that, my lord, two co-accused approached this honorable court. One, lordship has granted bail by order dated 3/4/2025. And on 9th of April, my lord, another co-accused was granted bail by coordinate bench of Honorable Justice Midul Kumar Kolita, my lord. So, my lord, in this case also, my lord, we have taken the grounds of prolonged incarceration as well as parity. But the difficulty is that, my lord, I could not annex the 50 notice and other accompanying documents. So if my lord may kindly call for the records of bail application number 403. There, my lord, all the entire records are there. This is very up to date. And thereafter, lordship may consider my prayer, my lord. That much prayer only at this stage, my lord.
Bail application number?
The records which are, my lord, tagged with BA number 403/25, if that can be tagged up along with this bail application, and thereafter, lordship may kindly consider my prayer for bail.
So now the question is that tagging of this record will be obviously after Bihu.
Yes, yes, my lord. Yes,
But now
yes.
question is that if in that case, otherwise from your submission, how many witnesses were examined?
No, my lord, in this, the order which lordship has passed on 3/4/25, that itself reflected that the next date is on 5/5 for framing of charges.
Oh, acha, not
Right.
yet examined.
Yes, my lord, yes. And my lord, I also appeared for one
So
of the
now you're saying that that record is tagged with this
BA 403/2025, my lord. So
Just
if registry may be directed to tag that LCR, my lord, along with this bail
BA
application.
403.
Yes, ma'am.
Then Boido, registry they were directed to take the yes record of BA 403/2025. You want any date fixed
My
or
lord, if
immediately?
23rd possible, my lord, convenient to this court, that much prayer, lordship may kindly consider. Or 25th, my lord, or
25th,
25th.
25.
Deep your life, deep your life, my lord.
16.
And for this matter, earlier rejected by Honorable Justice Rana, you mentioned it. So our, my lord, this is, he is in outlying bench, not in principal seat file.
That's what, that is a confusion in case what is happening, suppose out of same FIR, out of same heading. If someone has disposed of the matter, that can be placed before this court. If the honorable judge is outline bench or in division bench or some roster he is not taking, that is the issue. But the question is repeatedly told by us from the registry that if it is rejected by someone, then that has to be placed before that. That is the issue. That's what I'm saying just. Suppose, obviously he is in outline bench, most probably in Itanagar. So obviously it has to be after Bihu only, 21/4. List, we will just pass the order list before appropriate bench on 21/4.
22nd.
22nd. Okay then. 22nd. Aku pathai dise eta dekhise.
18.
Aku eta pathai dise. Ki korise eibo?
My lord,
No, the other one. 18, sorry, yes.
my lord, first time bail application. This one. So my lord, it is under 483. Petitioners are arrested on 19/3/2025. And for 5 days, they were in police custody, both the petitioners. And thereafter, they were sent to jail hazard. And since 24/3/25, they are in jail hazard. So they are not FIR name accused. In fact, my lord, one of the FIR name accused uttered the name of the two petitioners, and based on that, they were arrested. And as part of forwarding report, my lord.
They were all for 5 days police remand.
Yes. So in the forwarding report, lordship, at page 21 and 22, while seeking the police remand, page 22, my lord, relevant one, police remand, I would like to pray to the honorable court to remand the above accused persons for 5 days of police custody in the interest of proper investigation of the case, to find out other co-accused who are involved in this nexus. As per their statement, they have lots of vehicles, both four-wheeler and two-wheeler, with their associates at Silchar, Dimapur, and many other places, which are required to recover and verify the authenticity and ownership details. Now, during this 5 days period, neither the petitioners were taken to Silchar nor to Dimapur, and nothing has been seized and recovered from them. And my lord, the petitioner number 2, he is actually a cook of the petitioner number 1. Belongs to the same village at Moran and residing at Gorsuk area of Guwahati. So this is the case, my lord. We are not named based on the statement made by one of the second accused, FIR name accused, both the petitioners were arrested. And further, regarding the reasons of arrest, my lord, at page 21, here also, as per statement of the previously arrested accused person, Kaushik Chaudhary, these arrested persons, namely Ankur Gogoi and Parag Dihingia, are also mastermind of this nexus. And he handed over all the vehicles to Ankur Gogoi, who later on hid all the vehicles with malefied intention. So here also the name of Parag Dihingia is not there.
No, your petitioners is Parag Dihingia and Ankur.
Ankur, both.
So here the specific allegations against them only.
Yes. Against, in the FIR, my lord, lordship will find at page 13, only Pranjal Dekar and Kaushik Chaudhary. These two are the name accused. That they collected some people and in their name scooters were bought, and those people were told that they will get rupees 300 per day for their vehicles, and later on they didn't pay the bank EMI. Court served notice upon the informant and to some other victims, and when they approached these two accused persons, they threatened them. This is the allegation. Allegation is confined in the FIR only to the two name accused in the FIR, and we are not named in the FIR.
But this is a very
No,
nexus,
CD
I
will
think.
go for lordship, because FIR lordship will see after only investigation, their name have come up lordship, and it involves a large number of vehicles lordship. So at this stage lordship, let the CD come lordship, immediately after vacation lordship. Because this is quite, we have come across a number of cases,
May be
lordship.
considered, my lord, not CD also, because record reveals that there is no any such involvement. Because the ground of arrest,
Record reveals to otherwise. If we go by the reasons of arrest now you have submitted.
yes, my lord.
So this Kaushik Chaudhary arrested earlier also, and namely Ankur Gogoi and Parag Dihingia are also the mastermind of this case. So they used to do these things and handed over those vehicles to Ankur Gogoi and
Only
he
Ankur
used-
Gogoi, not to Parag Dihingia.
Now Parag Dihingia name is also that they are either a mastermind. So at this stage, without any
Yes,
appraisal of
my
the
lord,
case,
that
it may
CD
be
may
a
be
difficult
called.
on our part. Otherwise, you are saying that though they were in police custody
For
for
5
5
days.
days, but they were not taken to neither to
Silchar,
Silchar or not
Dimapur, or to
Dimapur.
any other place.
So if it is there, then definitely CD will speak everything.
Yes, ma'am.
So let us call for the case diary when it can be called for.
From Mongoldo, my lord.
The question is from Mongoldo, but we don't have this.
What to
That is
fi-
the issue.
Yes.
কি কৰিব দিয়ক আৰু কিবা এটা উপায়টো নাই। Your petition is behind the bar since when? 25/4.
24.
24/3. End of the April দিব লাগিব, we don't have any alternative. 28/4.
Standing 10.
Made, please, your lordship. Lordship, the mentioning was made before the Chief Justice Court, lordship. However, Honorable Chief Justice has already left for Kohima. And lordship, because
Now,
of-
just now I have also inquired with the registry people.
Yes.
They're saying that this is mistake on their part, so it should not be sent before this court. That is the issue.
that is there, my lord, the client will linger in the.
No, what can we
The
do?
litigant will linger.
But we are not alternative.
Can
That
we
too,
fix after
he is
Bihu,
the
lordship?
senior bench.
After Bihu lordship.
Obviously, it will come after Bihu. We don't have any alternative, so we'll list simply order that list before the appropriate bench after Bihu vacation. You want any date there?
Yes, lordship.
Okay, then we are fixing it immediately after Bihu on
Immediately,
21/4.
my lord.
21/4. Up to 20 is a holiday only, 21/4. List before appropriate bench after on 21/4. And in the meantime, we are not passing any order. You can
Gotcha.
place the CD and all.
It's a charge sheeted matter. lordship.
A case is charged. But we are not supposed to call for anything. You know the entire thing. So if you can produce the case record, and then it will be convenient for both the parties.
Will produce.
Otherwise, in the order that you have managed, that order was passed by me and there was detailed discussion was also there. I can understand. But the question is that the senior bench had already rejected. So we have immediately after Bihu, we are fixing it.
Much obliged.
Oh, appropriate bench.
19,
এটা এটা সব চেক করব লাগা হবে তখন এনেকুৱা হলে তো দিগদাৰ আছে Yes,
May it
Mr.
please
Chair.
your lordship. Lordship, this is an anticipated bail, although I have made an 52 of the petitioner lordship. Petitioner one is the lordship accused and petitioner number two is the informant in this case lordship. What happened lordship? May I take you to the FIR lordship? Why I make the informant as a party because she has settled lordship, she has no grievance lordship against this petitioner. Number one, so I make him a party lordship as and file this petition, joint petition lordship. Now lordship.
What joint
after-
petition? AB,
Eh,
you come with a criminal petition. It's not maintainable.
But lordship, my prayer is that my prayer is only for the petitioner number one. In all avertment lordship, my prayer is for petitioner number one lordship.
Don't make such submission. Petition number one prayer may be there. How can you can make submission
Yes,
that
lordship.
the informant has no objection or whatever. If you have any documents that can also be annexed.
That I have annexed here.
Then why you have made party?
Because
Why
I-
you have made party?
because she has said she has no grievance.
Whatever, you make a application for criminal petition then. She's no, she she needs any protection here? No.
No, I have not even pray for her protection.
Then how she is a party? She's not a
because
necessary party
she has
then.
Lordship, she has
Uh,
compromised the matter when the matter is not compoundable.
Submit all these documents here itself. Why you have made party? Or if you can, if you want to keep her as a party, then make the criminal petition then for quashing and all. That will do. But we, in AB, how it is, because AB is anticipated bail is for what? Those one person who has any apprehension of being arrested.
Yes.
So she don't have any, is she? No, then
I have not made prayer for her.
why you have made party? She is the party here. She is seeking anticipated bail.
Her document will not support lordship. She has filed an affidavit lordship.
Now see, the informant can appear before this court or assist the APP or PP at any stage of hearing of this case. For that reason, you no need to make her party as a party here. So now you what to do? Your petition, we cannot do anything because nowadays without the handwritten correction, things are not here.
Yes, lordship.
So you made your first problem. On the next day, either you may make withdrawal of this one immediately after Bihu on the or the in between, when is the working day will be here, you can file your petition.
Then I may allow.
You can withdraw this one at this stage because again, this correction or amendment will again you have to file another, the fresh cost title. That will face again difficulty on your part. So may make a party.
Lordship, may I pray lordship that all the originals are lordship, I have annexed lordship, that copy can.
Your
be-
originals are there.
Lordship, the
Okay, that
original,
prayer we
that
can-
certified copy, all this
Yeah,
copies.
these are certificate copies are here or original, any original is here.
Lordship, original, only the copies can be supplied to me that registry, release that copies, lordship.
Okay,
Original
that
is
can
not-
be done. Okay. Copies are also original here.
No, lordship. that's not-
Certified.
All the copies, lordship, that can be provided me, lordship. If released, lordship, I can
So
file it.
these are all photocopy.
Yes, lordship, but
Photocopy you want. How,
because
if original is there, we generally was to, what we used to pass the order. If the original is there, then
then I
definitely
may allow.
you are allowed
Allow withdraw, I may allow. to
withdraw
withdraw
this
and
one.
file.
These are photocopy only, not. And if your the wife or informant, if she wants to appear, she is at liberty, she can appear. We don't have anything to it. Through APP also, she may make submission or by engaging, or if that is the reason, if you already annexed those things, that may be a case for anticipatory also, I won't say, but at this stage, it's not possible. Withdraw for idea. Reach or file for fresh prepare will be
Fresh.
the liberty to file a fresh.
Fresh.
Okay, liberty to file it. Due to
File
some
it.
technical irregularity, he wants to withdraw this in with a liberty to file a fresh. Okay, we are.
File it.
20,
Give me one item. 20, yes. Hmm.
For three aspects.
Yes.
Date 13.
1-3.
One. In the previous civil dispute, the subject is regarding non-payment of amount of petty. Page number 14, next page. I'm reading the third para. Accordingly, I collected petty from various farmers and small traders from 2024 to 2025 at the rate of so and so per quintal amount to rupees 5 crore 57 lakhs. However, the opposite party has not paid a sum of rupees 68 lakhs. So I have paid 4 crore 89 lakhs. This is purely a civil dispute. So I have not been able to pay.
So total was 5 crores 57 lakhs.
Yes, contestant, I paid 4 crore 89 lakhs and I'm not paid 68 lakhs.
Where is the original one? FIR?
At page number 60.
Yes, Sharma. Your Mr. A couple. Had Mr. A couple, done in counsel for the petition. And also had Mr. B Sharma, the done it additional PP. Okay, I have gone through. You can take this one. It is a certified copy, I think.
This certificate.
It'll be the record. You want to get it in the record or you want to take it back? You can take it back. I have already gone through. So and so, this is an application, section so and so, in connection with so and so. Considering the nature of offense and the statement made in the FIR and also here in the submission made by learned counsel for the petitioner. I find it efficacious for you to extend the privilege of interim pre-arrest bill to the petitioner till receipt of the case diary. Okay, you will be under interim protection. You will be under interim protection till receipt of the case diary. When it can be listed? 135 and appear before the hour, there will be some conditions, abide by all the conditions. Otherwise, we are fixing it on 13.5 for CD, appear before the eye within 7 or 10 days. We are as direct. 10 days you need? 10 days. Okay.
21.
Thank you, Lordship. Lordship, in the same FIR, the Honorable Court has granted the bail to the co-accused. I am the Safai Kormi only. I have no connection with the case, but the branch manager and the assistant branch manager has got bail. The next date will be 25/4/25.
They are the branch manager SMA. Your capacity is?
In the bank.
You are the Safai Kormi.
Yes, Lordship. I have a minor son, Lordship.
No way connected, but can you no way connected in the areas of first. You are she or he? She is simply working as a Safai Kormi in the said bank. Said branch of the bank and no way involved in the alleged offense. She further submitted that the two co-accused persons have already granted the privilege of interim pre-arrest bail by this court, and considering the case of the present petitioner on the same footing, he also may be granted with the privilege of interim pre-arrest bail on the ground of parity.
Lordship, the next date, 25/5. Matter may be along with his matter also.
25/4?
Yes, 25/5.
Sharma, what is happening? In fact, there was a branch bank. There was some irregularity in the ATM machineries and all. So That's why there was a petition, but the subsequently it is seen that those manager, branch manager, they have also contact with the original authority concerned that there are some defects and all, machinery defect and so on. So on that basis, they were granted bail. So as she's saying this, she is a Safai Karmi. Let her be on interim periods, but till next year. 25. Okay.
Highly applies.
25.5.
No, 25-4. 25-4. 25-5? They are not giving any date. Oh, yes, I have
Yes,
seen
sir.
25-4. Vijaya Krishna is enough to pay.
Please. Anticipated bail application, Lordship.
Hmm.
But in this case, my clerk is doing one wrong, Lordship. One FI page is missing, Lordship. Did you?
One FIR missing.
FI page is missing.
You are supplied with same copy? Copy of FIR was missing. Oh,
One page.
anyway. Okay.
I'm going to correct. Lordship.
Hmm.
This case is, this is the owner of a vehicle, Lordship. From this vehicle, some owner only while this Lordship.
Hmm.
He was given the vehicle to lease to another customer. FI name, Lordship. Accused person is already granted bail by this honorable court, Lordship. Page, Lordship. 14. FI name, I'm the owner of the vehicle. Police call me for interrogation. I am ready to cooperate. Lordship.
No, but you were the driver
I'm the owner of the vehicle.
and the other petitioner was the who was already granted bail.
He's the FI name person.
Hmm.
Lordship, he is not driver.
The other co-accused lordship will find that the second page of the FIR. Lordship. Following an inquiry, it been made in the lead of so and learned that the TA wine shop Hologi so is been run by Bhakta Prasad Adhikari. So.
Run by Dr. Prasad. He is one Lohit Gogoi.
Owner of the vehicle, that is why the owner of the vehicle was also included, Lordship, in the last paragraph of the FIR.
Ah.
Lordship.
Lordship, at the time of
Arunachali liquor, na?
at the time of produce record, nothing is such found. Lordship order, Lordship, page 50.
No, this is the order of only making absolute. You are submitting this order only. This is the order where only the order of absolute was passed. There was no discussion, otherwise it's not discussion.
Page 50, I'm given the vehicle on lease, Lordship, to another person.
Who, to whom?
Lordship, one says Nabam Ranghi of Onasal body. Liquid, Onasal liquid also exists within the territory of Onasal.
The territory of Arunachal, they were brought from Arunachal to Assam illegally, but they were transporting those liquor illegally, the Arunachali liquor.
Petition is not involved. Lordship. I'm ready to go for it.
Heard Mr. number 22, heard Mr. L. Google, the learned counsel for the petitioner. And also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Gogol that the present accused petitioner is innocent and he has no way involved in the alleged offense. He is the owner of he is the owner of the vehicle from where the alleged recovery of Arunachali liquor was made. Alleged recovery was made. However, during that period, his vehicle was given on lease to one person, namely, equal number.
Page 13, Lordship.
Face
Nabam Rungi. Nabam Rungi.
to one Nabam 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 Rungi
Of
RUNGHI from Arunachal. However, he is ready and willing to cooperate the IO in further investigation of this. if he is granted with some interim protection. Next para. Mr. Sharma, the learned additional PP submitted in this regard that CD will be required to know the actual fact of the case. Hearing this submission made by learned counsel for both sides, considering the other aspects of the case, I find it effective to extend the privilege of interim priest to the present petitioner till receipt of the case time. Also, we grant the interim protection. And it can be
14.5.
you're fixing it on 14.5, appear before the IO within time.
I may allow to correct the page.
Wait, wait.
Since the page.
One page was
One page.
missing. Na? Okay.
92.
Yes.
May I please your lordship? 483 application.
Hmm.
I was taken into custody on 11/1/2025 and my lord 91 days today. And it is 21B. Case is charge sheeted, my lord. This is the first case I got that 47, 48 has been followed. But very mechanically, your lordship will be surprised to see. I brought it yesterday. I moved the page, it was not there. I brought the memo and in the 47, 48, printed sufficient evidence, printed. What is it? It will be amount to follow application of this thing. The judgment that which you have dealt in 2 cases I have taken, madam. You have elaborately mentioned what is requirement of grounds of evidence. Of sufficient. Printed it কই দিও আগে পরে প্রিন্টিং করে রয়েছে
Both 47 and 48
Yes.
are of same page or no?
no
You have already.
yes in the memo arrest memos also there is no mention or any ground and my lord I am ready to pay the time, my lord. 88 grams of suspected powder of heroin. Trial has not yet started. Charge has been framed. We have actually declined to, we have prayed for to face the trial. Statutory period is 60 days, madam. And it is charge sheeted within statutory period. Any sufficient condition, but I am from Silchar, Kachha district, not outside. I have given him one copy.
Watch. See, Mr. Sharma, if you go by the copy of 47, 48, the same thing is there.
Yes. No,
Whether it may be printed form, whatever.
no grounds.
I suggest my friend that it should be amended. There should be a communication from them. Now, of course,
And they are doing,
prosecution department has been started. They are taking up the matter, examining the case records also. I have heard yesterday. madam.
Mhm.
It will improve but slowly. It will take little time.
Heard Mr. S.C. Biswal, the learned counsel for the petitioner, and also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. It's an application under section so and so in connection with so and so. It is submitted by Mr. Biswal that the present accused petitioner got arrested in connection with this case on 11/1/2025. And and since then they are in custody. However, the case has already been charged within the statutory period of 60 days. And but considering their length of detention, the present petitioners may be released on bail, as the rigor of section 37 will also not attract in the present case, which is not of commercial quantity. Further, Mr. Biswas submitted that they will appear before the learned trial court below as and when date to be fixed by as and when the date will be fixed by the court. Further, Mr. Biswas raised the issue that though there was a though 47 and 48 notices along with the arrest memos were issued to the present petitioners, there were no grounds of arrest were communicated to them, which is required by লিখি দিব ঠিক আছে আৰু তেখেতৰ submission দিব that Sharma's submission দিব that after considering the materials available in the case diary, the case has been charged against the present petitioners, and hence he insisted to call for the case diary before passing any order on bail. To whose satisfaction it has to be?
Special Judge Kachar Silchar.
Kachar Silchar. Special Judge Kachar Silchar. Okay, will be granted. with you.
Will you break an NDPS matter?
Yes, obviously.
23, 14 hearing.
May it please your lordship. 483 bail application, my lord. Here is a section is 21B, my lord. 60 days offense and the petitioner is behind the bar since 48 days, my lord, as on today. And the recovery is 31.61 gram, however with container, my lord, and there are 25 plastic container, and they have not mentioned the actual quantity of the this contraband, my lord. With container 31.6 gram, and there is 25
Container
plastic
31.6.
48 days as on today, my lord. Further detention may not be necessary. 21B. Page 12 is the forwarding report.
Verma, we have received, is there 48 days he is in custody,
Lordship.
obviously.
Lordship, yes, 21 April will be 58 days, 50 to 50. 21 will be 58 days.
Perhaps not required, my lord. Already 48 days, and there is a long vacation.
No, but the whether FSL report has already been collected, not been collected.
FSL perhaps not required, my lord. We have not contradicted this contraband, my lord.
Oh, you know that is heroin only.
Well,
Very nice.
I am on length of detention, and the contraband 31.6 gram has been there, and they have not mentioned the actual
Yeah,
content.
that
my
they
lord.
have already submitted, yes.
This is my lord. My submission. Perhaps may not require, my lord, further custodial detention.
Heard Mr. Yu Khan, the learned counsel for the petitioner, and also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. And this is an application of the section so and so in connection to so and so, CD received. Where is the same? Heard both side. It is submitted by Mr. Khan, the counsel for the petitioner, that the present accused, how many petitioners we have?
One
Two.
petitioner.
One. The present petitioner is in custody since last 48 days, and hence, considering his length of detention, he may be released on bail. He further submitted that the contraband which is contraband which has alleged to have been recovered from the possession of the accused petitioner is 31.6 gram, including the weight of the container, but no actual weight has been mentioned in regards to the said contraband. Further, he submitted that the present no recovery was made from the conscious person of the accused petitioner, and considering his length of detention, he may be released on bail. However, he will appear before the IO as and when his cooperation will be required. Next para. Mr. Sharma, the learned additional PP submitted in this regard that there are sufficient incriminating materials against the present petitioner. However, till date, the IO could not collect the FSL report, which is still awaited. Next paragraph, considering the entire submission made by London Council for both sides, without going into the detail of the merit of the case, only considering the length of detention. I find that the IO got sufficient opportunity to interrogate the accused petitioner, keeping him in custody, and accordingly, I find it a fit case for you. To whose satisfaction? this was?
CGM Kamrup Metro.
CGM Kamrup Metro. Okay.
Deeply.
Time being 14.
Yes, Mr. Ahmed.
May I please, your lordship.
Mm.
Lordship, may kindly come to page number 65, lordship. Here, lordship, I am taking that ground, lordship, non mentioning of the ground of arrest as well as the information was not given to the petition. Page number 65, lordship. Here, lordship, altogether 5 persons were arrested. Out of those 5 persons, lordship was pleased to grant bail to out of those 5, lordship, 2 has been already granted bail, lordship. My lord, may kindly come to page number 65. This is the notice, lordship, under section 50 of CRPC. Now, lordship, may kindly come to page number 67. Inspection memo. And 68, lordship, harassment. And lordship, those 2 orders, lordship, one is Asrarul and another is Niarun, lordship. Both are the co-accused, lordship, arrested along with the petitions.
On the same day.
On this, one is on the same date, another is later, lordship. Asrarul, that is lordship, same date, 1/1/2024. Lordship, may kindly take up that order, Asrarul of lordship. Everything is same, even lordship forwarding is also same.
Then your petitioner, present petitioner is also arrested on 1/1/2024.
1/1/2024. Only difference is that lordship, nothing was recovered from the possession of the petitioner. It is mentioned in the seizure list. And lordship, the petitioner was the driver of the vehicle, lordship.
Your petitioner.
Yes.
The present petition.
Present petition.
Order আছে আপনি লিখলেও BA number 146 of 2025 for the co-accused আসলে ঠিক আছে and here I have already one thing already added. Nothing has been recovered from the person of the accused person will লিখা আছে না তার পিছত লিখিব he was the driver of the vehicle but আগত লিখি দিব the petitioner was the driver of the vehicle and nothing has been seized from the conscious person of the accused. That much.
Otherwise, everything would be same.
Okay.
Special just Sribhumi.
Oh.
Highly applies.
আপনি এটু লোক হ্যাঁ 1 BA 126
146.
sorry 146
146.
okay okay
Highly applies.
24.
this is last
Net with lordship.
yes
The 482 petition, my lord. He is not a, petition is not a FIR named the accused, my lord. Only issued one notice and a page 15, my lord. Annexure 2, my lord.
Hmm.
And on receipt of the notice, my lord, on apprehension, file this instant petition for
he received the notice only
notice only.
আচ্ছা
Annexure 2.
Hmm.
The page 9, my lord, is the FIR, my lord.
My lord, just one line I'll before my friend. My lord, in this case, I was objecting, my lord. On the last occasion, this matter came up before Justice M.R. Pathak, my lord. And your lordship will see there was a mistake in the petition. Both the cross title prayer and in the petition, the sections, there were some mistakes. Then, my lord, I pointed it out. Then the honorable court directed them to file an appropriate application
yes
on the last occasion, my lord.
yes the order
my
is
lord,
here
What I am told that, my lord, they have filed an additional affidavit. How can they correct an order by an additional affidavit?
There is
They ought
only
to file
there is a
I-
cross title there is a
Not only cross title, my lord, the mistakes appear in the cost title, in the body of the petition, in the prayer, in the FIR.
My lord, only one typographical mistake. In place of, my lord, in 351, it is written as 35 surplus one. Only one is not, my lord.
No, see,
written.
sometimes it
In that
happens.
regard, my lord,
That's what
additional
I'm saying, that sometimes it happens that say someone prayer portion, there is some mistake.
My lord.
Then we may get it corrected and typed and it will be read as so and so. But entire petition is not possible, but for half a portion, it may not be possible.
My lord,
So why don't you?
in this regard, my lord, additional affidavit. has
And
been
that
filed.
apart, there is an order by this, the one coordinate bench of this court that appropriate application by the petitioner is the matter after filing of the application. So in spite of that order, why you don't
But,
have any?
What additional affidavit has been filed?
My understanding, I has to be filed.
IA has to be filed.
Obviously, I can.
It's
be
a
filed.
prayer for correction.
Yes.
Once the IA is
Yes.
allowed, then his petition will be heard.
Yes.
Then, I mean, that's how
Yeah,
we do.
yes, yes.
By additional affidavit is for some additional ground, additional document. By means of an additional affidavit, we cannot correct an petition.
So instead of filing an additional affidavit, you can have very well file an I as they have also submitted.
It is simple, only one finger mistake,
not
on
simple,
one,
Lord.
only one
Nowadays,
is
Lord,
not
the
mandatory.
mistake in the cost title cannot be corrected
Well,
in this
that's
manner.
okay, my lord. Yeah, it is written on that 335 surplus 2. It would be 351. Only one was not come under.
You cannot explain by that manner.
That is
Your
fine.
one or two will change the entire spirit of the section, in fact, itself. By adding one or two or deleting one or two, that will cause
Then I-
35,
In earlier
suppose
disclosure-
352, there will be differences.
My junior file this edition, I may be allowed to file this I petition.
Okay, then as uh, uh, as per order dated 27/3/2025, the petitioner was directed to file an appropriate application for some correction of in the for correction of some type of for some typographical correction, but it is submitted by Mr. Islam that the one additional affidavit had filed instead of filing an interlocutory application inadvertently. Mr. Biswas, the learned counsel appearing for the respondent number 2, as well as Mr. Sharma, the learned APP, also raised objection and submitted that it is proper way to file an interlocutory application instead of an additional affidavit. Accordingly, the petitioner is hereby directed to file an appropriate application. List the matter after filing of the appropriate application by the petitioner. Okay. Thank you. Same to you. Thank you. Same to you. I'm just feeling something else today by rising at 12. It's very rarely in my part.